we're getting started. And let me see here. I got to figure out, I guess that's not going to do me any good. I'm looking at my world clock. Okay, so thank you for being here today. And it's great to aesthetically see you again. I've got a little bit of a different lighting environment today. I'm actually in the middle of a pretty powerful electrical storm. So, but my internet is coming off of the chip here on my computer. So hopefully that won't go down. But in the meantime, we're in great shape. So let's talk about what we got going on. Here we are, Greater San Diego Association of Realtors. We are trying to go next screener. Buyer representation agreement. We're going to be talking about paragraphs number 7 through 10. And then next week it'll be a wrap. Next week it'll be paragraph 11 and we're done. But today, as always, we always say, you know, we're going to be talking a lot of stuff. It's going to sound like it's legal stuff. And, you know, sometimes it's really pretty close to it. But I'm not here to give you legal advice. I'm not a practicing attorney. I do a lot of trial work, but it's certainly no money in it for the rest of us to have to go there. So in the meantime, not intended to be a substitute for the advice of your broker, nor for that of your attorney. And please consult with them as appropriate. And education, so SDAR will send you a whole bunch of material that I created for our webinar today. And that'll happen right after we're done. And so if you were here, then they're going to go ahead and send it to you. Okay, so that's kind of the new thing. Thank you to SDAR for doing that. They literally go in and make sure that you have everything I've done. This morning's conversation was how to write counteroffers, multiple counteroffers, and backup addendums, and I thought that was a great event. And so there's a really big package there. So if you want that package, then send an email to education@sdar.com, and they will get all that out to you. It was a really good webinar, okay? So we had a good time with that, all right? And then finally, if you want, you know, I do send out a newsletter once a week, and it's got links on, little clickable links that go right straight to the webinar that we're doing, so you don't have to go through a bunch of stuff. If you want to be on that list, send me an email, Kevin@Burke Real Estate Consultants with an S.com, and we are good to go. Let's go ahead and get talking today. Let's talk about our subject matter, which is going to be our buyer representation agreement and where we actually are right now on that. So let me take a look. So last week, last week, what's this say here? Oh, that's over. We've already, so that's good. Last week talked about the agent's duties, and we discussed the concept of if you define your duty, you limit your liability, and that was a really important lesson for a lot of us. So when you define your duty, you limit your liability. When you tell them, this is what I'm going to do for you, they get later on and with all kinds of problems and say, well, you know what, you're supposed to do this, you're supposed to do that. No, I actually told you in writing what I was going to do. So today what we're going to talk about is we're going to talk about what is the buyer's obligation. Then we're going to go into other terms and conditions. Then we're going to talk about attorney's fees and the entire agreement. So just giving you a little heads up in advance of what it'll look like. So again, really good dialogue last week on paragraphs 5 and 6. And by the way, I teach that in my continuing education for attorneys class as well. And I have them write out paragraphs 5 and number 6 to memorialize the fact of what it is that we actually do for a business. What do we do for a living? Here we're actually telling you, here it is on the form. 99% of the people I talk to have no idea that that's out there, okay? So, so that being said, let's talk about now, we talked about the agent's duties, we talked about the agent's obligations, now let's talk about the buyer's obligations. So obviously remember that in any contract, there has to be an exchange of promises, and one of the exchanges was, here's what I'm going to do for you, but now let's talk about what you owe me. Okay, so beyond commission, that was paragraph number 3. Okay, but what do you owe me? So what are your obligations as a buyer? Well, as the buyer, you agree to timely view and consider properties. So you don't just go to sleep for 3 months or 6 months or however long the period of the contract is, okay, selected by the broker, and to negotiate in good faith. So when you're writing offers for half of the asking price of the property, you are not paying attention, you're not acting in good faith. And so we need to talk about that, whatever it is that you're doing to sabotage the transaction. And listen, it happened to me at times, and I hope that it's not happening to you. But when it does, it just leaves you a pit in your stomach, because it's like, you know what? I work hard for a living. I don't need to work, with somebody that just doesn't have any desire to be honest and upfront with me. So to negotiate in good faith and to acquire a property, period. So your job, Mr. and Mrs. Buyer, is to find a house. I'm going to help you find it, but your job is that if I get you what you're looking for, then you agree that you're going to buy it. And remember what the language was that we said, if I find the perfect home for you, will you write the offer through me today? Okay, that closes a lot of doors. All right, if I find the perfect home for you, that is kind of what we're doing. Will you write the offer? Are you ready to do that through me, not through your cousin or your aunt or somebody up in Northern California today? Or are you going to tell me now I don't need anything for 2 years? So that's why I say this is a good closing question. This is the kind of thing I say to people when I say, listen, I just want to get down to it. Are we going to, what are we doing? Right? Or what are we doing? I want to make sure that we are on the same page, okay? But if you're not looking for 2 years, then I guarantee you the properties that are available today are not going to be available in 2 years. They may not be available in 2 days. So, if you look at our unsold inventory, it's getting to be a crisis again. We really have only 4 months of inventory. I mean, literally, if we stop taking listings, we are out of property in 4 months, okay? That's a number. So you need to be telling your buyer that. So it's really important for you to know your market. And so when people say to me, well, what do I say if they ask me a question? And you say, well, you give them the answer, right? But the bottom line is, what's the number one question they're going to ask you? How's the market? It is out of control, okay? So I'd rather work with buyers because I don't have to play around with spending money on sellers. But you know what? That's I always have one of these agreements. I never have to worry about my buyer being a flake, okay? All right. My father used to call them flakes. He was a broker for 40 years, and he has some choice words for people. So he's not quite as politically correct as I am, but okay, I get it. So buyer further agrees to act in good faith towards the completion of any property contract entered into in furtherance of this agreement. Within 5 or however many days from the execution of this agreement, buyer shall provide relevant personal and financial information to the broker. Okay, I'm going to call that a pre-approval letter from the lender. Okay, I've had it happen enough times where the buyer says, don't worry about the money, I got it. I'm worried about the money, right? Especially when you tell me not to worry, I'm going to worry, okay? So bottom line is you're going to get a pre-approval letter. You're going to do it. You can use your own lender, but I want another one from a lender of my choice, somebody I know, and then we're going to go to Dodge with it, okay? All right, and financial information to the broker. Be careful about what you put in your file to assure the buyer's ability to acquire property described in paragraph number 1. So remember back there in paragraph number 1, we were talking about the subject matter of what we're trying to do. Here's what they're looking for. They're looking in these 5 zip codes. They're looking for single family home. They're looking for a place with a pool, whatever, okay, that, that they agree that, we're going to be working towards that end, and we're going to be working towards that end together. If the buyer fails to provide such information, or if the buyer does not qualify financially to acquire property described in paragraph number 1, this is the let me have this deal fast paragraph, right? Buyer doesn't give me information, we're not working well together, and guess what? I'm not going to keep working with you, or you don't qualify. So, listen, we all want to look at $10 million homes, but maybe our price range is 30 million. I don't know, but we need to find out. We need to talk to the people that are actually going to lend the money and have those people tell us how much you can buy. Okay, so nothing personal, but there's no sense in us going out and looking at $10 million properties if you can afford to go to 30, and you find out later on you can go to 30, and then now you're looking at me like, well, how come we're only looking at 10? We've been wasting our time. So let's try to nail that down. And remember, on paragraph number 1, you've already had this conversation with the lender because you needed to bracket the price range that the buyer was going to be looking in. So if the lender says they're approved to go to 10 million, I'd probably write my bracket in paragraph number 1 to be, 8 million to 12 million, and something that's reasonable, and something that I can pin it down. Okay. All right. Okay, so if you fail to provide that information, or if you do not qualify to acquire the property, then the broker may cancel this agreement in writing. And listen, I need to be able to get out of this deal, love you to death, but at the end of the day, you know, not be a good relationship. I mean, again, if you can't afford to get the home, or if you aren't going to cooperate with me in getting that financing, then chances are pretty good I need to go work with somebody else, or I'm just going to go spend my day at the beach. Okay, all the years I've lived oceanfront in Del Mar, and probably stepped my feet in the sand maybe once maybe. Okay, so you know, it's just one of those things. All right, so but I may take that opportunity if you can't, you know, get a loan, or you know, you're not quite what you said you were going to be. Okay, and of course I'm a little more tactful about that when I'm talking to the buyer. Buyer has an affirmative duty. That means you must do this. You must take specific actions to do it. Okay, affirmative duty to take steps to protect for herself, including discovery, okay, of the legal, practical, and technical implications of discovered or disclosed facts. So, you know, you can't go, you know, I'm counting on the agent to do all that work for me. You know, we're just not going to work that way. Okay, you can't come back and say, you know, well, I figured that the agent was, you know, told me everything that was relevant about the property. Obviously, they missed a bunch of stuff, and so then I bought the house not knowing what I was getting. I'm sorry, this is actual lawsuit. Okay, now, let me tell you, you don't want to have that conversation. Okay, so the buyer has an affirmative duty to take steps to protect him or herself, and this conversation comes up in court. You know, it's like, did you, the buyer, do things that you needed to do? I had a case on this not long ago, and the plaintiff in the transaction said, you know, well, I just kind of figured that the agent and the seller were telling me what they knew about the place, and so, you know, I didn't do anything else on my own. And it's like, no, that's not how it works. Now, folks, the reason that this document is so important is because it says right here, you have an affirmative duty to take those steps, including discovery of legal, practical, and technical implications of discovered discovered or disclosed facts, right? So things that you were made aware of, you need to go digging around and finding out if that's going to be a problem for you or not, okay? And investigation of information and facts which are known to the buyer or are within the diligent attention and observation of the buyer. So listen, if we're in the house and you see that, you know, that the doors close themselves, right? The house isn't haunted, okay? Or windows are falling out of the frame, or there is this huge stain around the skylight. You know, these are things that you can't just say, well, I didn't know what that was. You have an obligation to investigate that information if they're diligent attention and observation. So those are things that we call latent defects, right? You know, the stuff that are fairly, you know, we want the stuff that you can see, and then we'll worry about the stuff that you can't see, okay? Those kinds of things, okay? And even us as real estate agents, we get the same thing. We do not have to dig or poke or you know, drill, tear up carpet. We don't have any kind of thing to do with that. We're not going to go down that path, okay? All right, okay. So, and again, diligent attention and observation. So, you know, you had to go and look through the property, not just say, well, that agent, I wanted a 4-bedroom and that was the last thing I did with it. You know, that's not going to be what we're going to do, okay? Buyer is obligated, excuse me, and agrees to read all the documents provided to the buyer. I love that, right? How many times you ever buy a house? You know, who gives you more documents than anyone in the world but the lender, right? So I don't want to hear any complaints from the buyer, because guess what? My stuff's nothing compared to what you're going to be signing with your loan. And you're going to be breezing through that, aren't you? You're not going to be reading any of that stuff. So I want you to read my stuff. And when we have this conversation and I say it's very important for you to read this document, then I'm sorry the SBSA is 13 pages long. I'm sorry the purchase agreement is 10 pages long. I'm sorry that the property looks like War and Peace, right? There's so much stuff in there. You have an obligation to go through all that stuff, okay? You are involved in the single most important transaction of a lifetime. Most people don't ever do this. Some of them do it a lot, but you need to take it seriously and don't be putting your burden back on somebody else. You need to do your own due diligence. You need to do your own investigation into the property. And God knows you've got to read the stuff we give you. Okay, so buyer's inspection advisory, that's a big deal. You need to be reading what that says, because you know what? You need to be doing those inspections, okay? So buyer agrees to seek desired assistance from appropriate professionals. So, buyer comes to you and says, well, I want to do a 1031 tax change. First thing I'm thinking is tax and legal advice. I'm going, that's so exciting. Let's do it. I'm going to give you a list of people for you to talk to that can help you with 1031 tax exchanges. Well, I don't really want to pay anybody for that. So can't you just tell me? Well, I'm sorry, a 1031, that's tax and legal advice. So I'm going to be really careful about what I say. I'm going to give you literature from the California Association of Realtors, but you really have to, you can't rely on that. You really have to do your own due diligence, run your own observation. You really need to hire the appropriate professional. So you need to hire an attorney, you need to hire an accountant, you need to hire an enrolled agent, you need to hire the appropriate professional for what you're trying to do. And yes, I have a whole bunch of them I can refer to you that I know are good. I'm not going to send you just one. But yes, I will tell you who I use, and then you just decide what you're going to do. But my defense is always going to be, I didn't tell you to use them. I told you who I use because I like them. But you know what? Just like any relationship, it may be good for me and not good for you. Okay. Those are the kinds of conversations I have with my buyer, and my buyers appreciate completely my sincerity and appreciate completely my honesty and my integrity. Okay. And that should be the same thing for you too. Okay. So they need to be discussing with appropriate professionals, not you. So here's the other part of it. You call the attorney and you ask the attorney a question, and then you call your client and you tell the client what the attorney said. You know what? You're going for that. Don't do that, right? Your client needs to make the call, and you're sitting there and you're going, well, gee, they'll talk to me for free. Listen, I tell my clients, I say, listen, the first half hour with them is on me, right? 90% of the people I work with will give you the first half hour for free. Okay, so it's on me. I'm going to refer you to the appropriate professional. You're going to make that call. I am going to be the interloper. I am not going to call them for you because I know your situation. Your tax situation is very different than mine. Okay, I assure you of that. All right. So if I go and I find out the information, and then I tell you this is what they said. We've all heard hearsay, we've all heard those kinds of things. So you know what? And now or I didn't ask the right questions, or and it's like, no, we're just not going to do that. Okay. So be safe and have your client talk to those people. And you know what? They're going to say, well, they want $250 an hour. And you say, so how many hours do you need them for? 2. Okay, so that's $500. You're buying a house for $1.5 million. I think we'd probably spring for that, right? Okay, and it's not appropriate for you to pay the professional, by the way, because when you do that, then you may become the warrantor of the product. Okay, all right. But any advice that you relay becomes your advice, and you are not an attorney, you are not a tax professional. Stay away from it. Send them to the appropriate professional. And frankly, your broker should have a list of people that they like you to use. And so we have a list in our office. More than happy to send it to you if you want. But I tell you that that list works for us, works for our agents, but at the same time might be a better list someplace else. I don't know. I just know this is what we use. Okay. All right. Okay. So buyer agree to seek the desired assistance from the appropriate professional selected by you, not by me. Okay, so real estate agents, listen to me here. Stop getting in these big fights over who's escrow and who's title. Okay, because you know what? That's did the buyer pick it or did you pick it? Okay, all right. So happens all the time. Okay, all right. Where did I go? Selected by the buyer, such as those referenced in the attached buyer's inspection advisory. Folks, I really like that form. Okay, it's just a very short version of the buyer's election of inspections, or if you like to use the CAR form, the one they copied from us, the buyer's inspection elections, try to make it look like it wasn't the same form. So their form is 1 page. Ours is 8 pages. I think ours is probably a little more robust. And I can tell you I've had to proof that document. So it's a good one. Okay, so it's a good document. All right. So that being said, Well, let's go ahead. All right. So we want them to do all that. And by the way, they're going to sign the buyer's inspection advisory. Please don't separate it from the contract. And then they're going to later on sign the SDAR form, the buyer's election of inspections form, the BEI form. Okay. All right. Let's take a look. Oh, first of all, I'm sorry. Questions? Okay. Quiet. All right. Okay. Questions good. No questions. This is a very interactive meeting, as you all are going to know. And of course, darn it, I just realized I don't have my other computer turned on here. And so as a result, I can't see. Hi, Dawn. Alina, welcome back. Art, you're the best, buddy. Serena, cool. Okay. All right. So let's take a look at paragraph 7B. Buyer shall notify the broker in writing. Now, listen, we talk about this all the time. When we do the buyer representation agreement, we need to have also the buyer material inspection buyer material issue form. Now, I have a little bit of a problem with the form, and the reason is that when I send it to the buyer doesn't have the ability to actually fill it out online. It only has a place, the electronic signature platform only has them signing it. So get good at using Glide. Okay. So it's a member benefit. You guys, you got it. We're paying for it for you. Sebastian Tonkin put it together. I was just on the Lone Customer Advisory Board meeting today, and they're talking about Sebastian being a big competitor. So you need to be thinking about that. That form's a good form. Okay, he uses Glide. Glide will fill in your disclosures for you, and that may be one of those forms that you need to have filled out by your buyer. I see it so oftentimes not being used. But here's what happens with the buyer material issue. The buyer says to you in the form, here are the things that are important to me. So if they put in there that I don't want to live near high power lines, then you maybe don't want to sell them a house that's near high power line. Okay. Or if they put in, I want to be in this school district, then I probably would send them the demographic information from the authority, like the school district, that says whether or not the property is in that school district. I'm not going to look up the school district. I'm not going to look up the property to see if it falls in the school district. No, I want them to do that. So I'm going to send them the demographics that says, here's a list of all the properties where they fall in what school districts. Go crazy, okay? But my buyer material issue forms does. It actually says to me, okay, Mr. and Mrs. Buyer are saying, here's what's important to us in the purchase of the property. So you need to pay attention to that. If anything else, it really just serves to notify you, these are the hot buttons, okay? Now, 9 times out of 10, the buyer just says, nah, I don't have anything important. I draw a line through it. Oh boy. Okay. So then later on, of course, when they buy the house, they say, well, I told you that, I wanted to be in this school district, and you sold me the house across the street from it. I'm having to bus my kid to school 20 miles away. Then, you've got a defense. You've got a form that says, I asked you what was important. Here it is. You put nothing. You said there is nothing. Okay. Not just you left it blank. All right. Okay. Everybody good with that? That BMI form. In fact, you know what? Let's bring that form. I want to show you that form. Okay. So I'm saying that with confidence. I'm hoping that I have it here. Over there. Boy, I'm hoping. Yeah, there it is. Good. Here's my buyer material issues form. I really like this form, folks. So up here at the top, buyers entering into a written agreement with the broker with me for the purpose of locating and acquiring real property, a manufactured home, or a business. Okay. B, buyer has made or is contemplating making an offer to purchase such and such a property. Here's the APN number, County of San Diego. Buyer's obligation to disclose material issues. So in accordance with the terms and conditions of the written or oral agreement between the buyer and the broker, the buyer agreed to notify the broker in writing of any material issue to the buyer, such as not limited to information on or concerns regarding any particular interest or important to the buyer. So what's important to you? You need to let us know. Okay. Buyer's disclosure. The following issues are important. They're important for all properties, or they're important specifically for only this property. And then paragraph number 4 talks about, again, my favorite part. I'm defining my duty. I'm limiting my liability. So here it all is. I'm not going to read all this to you again. We covered this last week, 5 and 6 of the buyer representation agreement. But we talked about all that. Okay, you're not going to hold me liable for conversations about square footage. property boundaries, all the stuff that we get sued over. I'm not going to play that game with you. Here it is. I told you again in this form. Okay. All right. I got no dude. You know, this is essentially a repeat of everything that you saw in the buyer representation agreement. So again, I'm not going to spend any time on that. You can go ahead and read it when you're ready. Okay. Or take a look at last week's video. Last video was really good. I thought we did a really good job on that. So we knocked it out. Okay. So look, now we're going to go back to our documentation, and now we're going to talk about any material issued to the buyer, such as, but not limited to, you know, the lore of that, buyer requests for information on or concerns regarding any particular area of interest or importance to the buyer, any of those material issues. Then in bold print, parties to 1, indemnify, defend, and hold the broker harmless from claims, disputes, litigation, judgments, all that good stuff arising from any incorrect information supplied by the buyer. So, oh yeah, I didn't tell you that, you know, I had to have a swimming pool that had jets in it or something like that. You know, guess what? You didn't give me the information, not liable for it. Or from any material issues that buyer fails to disclose writing to the buyer. So none of this verbal stuff, folks. I want it in writing. And they agree to pay for reports, inspections, and meetings arranged by the broker on the buyer's behalf. So if you ask me to schedule the physical inspector, the assumption is you're going to pay for it. And so again, here I've got it in writing that the buyer understands that. I don't want to have that situation where, you know, I show up at the physical inspection, the inspector is there, and the buyer can't make it that day. Oh, by the way, their checkbook can't get either. Guess what? You know, you're not complying with our agreement, okay? Again, if I have this agreement with them in writing, I have something I can enforce, okay? All right. And then finally, buyer is advised to read the attached buyer inspection advisory for a list of items and other concerns that typically warrant inspections or investigation by the buyer or other professionals. Weird things about the house, things that are within your diligent observation. I'm talking about the buyer, right? The buyer going through the house, they just can't, you know, they're not allowed to just go, okay, I'm going to ignore it, okay? Or they see this crack running from the corner of the window, you know, down to the ground, and you could put a quarter in it, right? You know, they can't just say, I didn't see it. I mean, it's right there. And in fact, when I'm walking through the house, I'm saying to the buyer, you see that crack? Wow, that's interesting. I wonder what that is. Okay, I probably have a good idea what it is, but I don't diagnose. Remember, I disclose, I don't diagnose. So, wow, that's an interesting crack. I wonder what that is. Okay, guess what? Puts the buyer on notice that they need to be figuring out what that is. Okay, all right. I don't want them coming back later on and saying, well, you didn't tell me I was going to be important. I said, listen, I told you about the crack. I'm not a geologist. I'm not a structural engineer. I'm not a seismologist. I'm none of those things. But if that part of the house breaks off, you know, and 2 weeks after closing, real lawsuit, 2 weeks after closing, you know what? I told you about it. I put it in my agent's visual section as well. Okay. All right. Everybody good? Questions? Seeing none. Let's go ahead. You can always pull me back. You know that. Okay. So other terms. Conditions, the following disclosures or addenda are attached. And so again, my buyer's inspection advisory, there's no way for you to uncheck that box. Okay, it is attached to this document, separate out. I mean, if you give them hard copy of everything, make sure that form's included. And by the way, you notice it's the BIA-B, right? And then when we have it on purchase agreement, it's got a different extension to it. Okay, so all right. So statewide buyer and seller advisory. I mentioned that a minute ago. You know, I'm going to tell you something. It's one of the most frequently missed forms. When I get an offer from another agent, it never has the SBSA. It's like, why not? Right? I mean, it's included in your forms. Okay, I have it included in my template. Okay, remember I offered to give you my templates. I have it in my template. Why would I not include the SBSA? Remember the old days we had to initial the bottom of each page. It's 13 pages. Today, all you got to do is sign the 13th page. Okay, it's complicated. All right, make sure your client has seen it. Okay, and so a lot of times we count on the transaction coordinator to catch us up in the transaction, and they're going like this. They're pulling their hair out, going, "What are you doing? You know, you dump this file on me. It's closing on Friday, and you didn't do anything." And so that SBSA is an important form. One of the most frequently missed forms. Today we did the counteroffer, mobile counteroffer, backup offer addendums, and it was right in my template, okay? Right in my counteroffer template, it says, you know, we want the APA, the LAD, the SPQA On the CAR side, we want the AC, the confirmation real estate agency relationships. We want the MCA. Why didn't you include that? Right? Okay. It tells the buyer, it tells the seller that we don't have a crystal ball. We can't tell you what's going to go on the market. Market goes up, market goes down. Anybody know what it's doing today? No, I don't know. You know, it's maybe it's going up in Hamul, but it's going down in Del Mar. All right. So you know what I'm saying? Okay. So I want to make sure that I include those addenda. And let's take a look at that form, by the way. I want to take a look at my SBSA. I don't want to spend a lot of time on it, but I do want to discuss it. So here is my SBSA, and this is my statewide buyer and seller advisory. And again, you know, I like what they put, CAR put in here. It does not place local condition disclosures. Okay, additional advisory disclosures may be attached. So here's what it does. So this is not a substitute for local area disclosure. And interestingly enough, when in my travels, you know, depending on whatever committee I'm on, you know, to the form that they always use, Canada, they always use to describe a good local form. They always use San Diego's local area disclosures. Okay, the local area disclosures form is just a great form. You need to have in your transaction. It is the standard of care. It is the standard of practice. So I would make sure that it's in your transaction. But that form doesn't replace the SBSA. It's a statewide form. And the statewide form doesn't replace the LAD, okay? Much like the SPQ does not replace the SPQA, okay? They're forms independent of each other, okay? SPQA is, think of it as an extension of the SPQ, okay? So anyway, and those two forms came about because the legislative intent, you know, when they created the transfer disclosure statement, was just not complete. Okay, so here we go again. I love it because I had this form was used in a lawsuit recently. I loved it because, you know, the attorney for it said, "Well, did you sign this document? Well, let's take a look at some things here: buyer's rights and duties, seller's rights and duties, broker's rights and duties." Okay, so it actually breaks it all down for you. And what's funny is this is a newer form than the one that was in the lawsuit. So now they've done a really good job and they've created a chart for you, which I just think is the best, right? Maybe not the best chart, but I just think it's a really good idea to tell people what you're going to tell them, then tell them, and then tell them what you told them. Okay, and that's kind of what this does. Okay, so you really need to take a look at this. You know, some of us, if we're looking at this now for the first time, you're sitting there and you're going, "Wow, I didn't even know we had that." Okay, will you do me a favor? Will you read it? Spend some time with it. You know, you're not doing anything else. You know, you're petting the dog at night or whatever, and you're you know, watching TV, and maybe you pull this up on your tablet and just take a look at it, because it says all the stuff that you are looking for it to say to protect you from your own client. Okay, it protects us from our seller. It protects us from our buyer. You need to be using this form. Okay. And again, as I said earlier, notice there are no places for them to initial on the bottom of the pages. You know, investigation of physical conditions, great breakdown. All right. Environmental hazards, easements, formaldehyde, geologic hazards, inspections, mold. My favorite subject, mold is gold, right? So, you know, you and I aren't allowed to use that word. We don't have the qualifications to be able to determine the difference between mold and mildew, for example, or you know, what stachybotrys is, you know, something like that. I happen to have a graduate degree in hazardous materials management, so, you know, I probably talk about it, but I don't tell anybody I got the credential because I don't want to tell out to be an expert. Pets and animals, soil and geologic conditions, square footage, lot size. How many times we got to tell people that we're going to be held liable for square footage, lot sizes, boundaries, and surveys? And then what do? We go ahead and we change the square footage from, I was just having this talk with a broker from Central California. And I said, you know what? I tell people all the time, accept the tax data. If you change it, be prepared to defend yourself. Okay. And maybe that's okay. But I sold a house that tax record showed it was 800 square feet. This was 4,000 square feet all day long. I'm telling you, it was a big one. Okay, it was definitely not 800 square feet, but I don't know, right? Because I don't do square footage. I don't do lot sizes. I don't do boundaries. You know, where's the property end? Oh, over there by the fence. Uh-oh, you know, it doesn't, right? Okay, all right. Water intrusion, well and water systems right up there. wood destroying pests. I think that would make an interesting reading for a lot of us. I think that everybody's aware that there are conditions that may lead to a problem with our wood, but we can't use returns. We don't have applications in that respect. Okay, all right, property ownership. Here's my ADUs. All right, these are important things. Okay, I'm not going to go through building permits. I'm not going to go through all of this, but future repairs, replacements, and remodels. A lot of this, excuse me, paragraph number 6, HVAC systems, historical designation. Sell a property in Portland, you will very quickly get used to the historical designation and what that translates to. All right, so insurance, title insurance, after foreclosure, land leases, marijuana, owner's listen, this is, some of us it might do us well to just read this stuff for our own good. Okay, and we'll update it as time goes on. Short-term rentals, views, school security, water shortages, the hypothetical water shortages in California, Belarus assessments, stuff we might read it and just realize, wow, there's more to this than I thought. There's more to real estate than I thought. So we create all these forms and we create golf course disclosures. you've heard of errant golf ball insurance. So there's actually insurance to cover you in the event golf, from the golf course takes you out or takes your house out. There's actually insurance available, but most people don't get it. So we need to make sure everybody's aware of the fact that it is available. Okay, neighborhood noise sources, death on the property. How many people call me and ask me about Civil Code 1710? 1710 says I have to make a disclosure. Well, what are all the other criteria? Well, those are important things. Zones, the natural hazard zones, lead-based paint, FERPTA. Okay, lots of really good stuff in here. Everybody see what I'm talking about? So spend time on this. Liquidated damages. I like the explanation of liquidated damages. I spent 3.5 hours on it the other night. Teaching the attorneys how to handle that. So, you know what? Be careful. Don't think you know every. I had somebody call me up this morning and say, "Well, I know what the legal definition of this is." And I went, "Oh, you do? Wow! I don't know if anybody say that to me, but okay." Anyway, non-confidentiality, all this stuff, online wire transfers, all this stuff, folks. You need to spend a little bit of time and go through it. Okay, and that's pretty much it. PACE loan. Notice that we attach. In our template, we attach the APA and the LAD to this. We attach those in several different places because, we want to make sure that everybody, we want that included in our transaction. Okay, all right. Let's go back to our forms and let's look and see where we are. So you could put other addenda in here, as I just showed you from the SBSA. I'm probably going to check the box for sure. I'm probably going to put in SDAR's form APA, Addendum to Purchase Agreement. But you might have other addenda. Talk to your broker. Your broker may have things that they want in there. This is a good time to put in the affiliated business disclosure, okay? Or controlled business disclosure, whatever you're going to call it. Let's take a look at my attorney's fees provision. My attorney's fees and my entire agreement. And so my attorney's fees provision, as before, is considered malpractice for an attorney to write a document that does not contain an attorney's fees provision. So if you don't have the attorney's fees provision, then guess what? Your attorney, doesn't collect their fee from you or from the other side if you're the prevailing party, right? You might have some problems with that. So you got to make sure you have that attorney's fees provision in there, and here it is, okay? So attorney's fees in any action proceeding or arbitration between the buyer and the broker, because remember, this is the buyer representation agreement, regarding the obligation to pay commission, because that's usually what the dispute is under this agreement, the prevailing buyer or broker shall be entitled to reasonable. And as we have said before, I don't know what reasonable is. It could very well be, something that a judge is going to have to decide. So there's that reasonable man standard by law. And we may have to count on the judge to tell us what reasonable is. Okay, we'll turn the costs. What is it? Somebody said the attorneys get 25 cents a page for copies, but the homeowners associations get 50 cents a page. 50 cents a page for copies. I always wondered why. I thought the stuff came from the attorney was more important. Okay. All right. Except as provided in paragraph 11A, and we're not going to get to 11A until next week. So we'll discuss that at that time. Okay. So I don't know. Remember what we said before. We always have the attorney's fees provisions in our agreement at the state level. Okay. And we actually have the STR's risk management committee as well. But remember, there are attempts now to limit the amount of attorney's fees. So if you look at your lease rental month-to-month agreement, you will see a limitation on attorney's fees to $1,000 or blank. In fact, I had a lease agreement came to me one day recently where the agent put in $10,000. So I don't know where they came up with the number, but I'm hoping that the client gets that. So there's still a limitation on attorney's fees, not reasonable, but in this case, it was held that $1,000 was enough, or $10,000 would be enough. Remember, whatever you stand to lose, so does the other side, or differently stated, if you're going to limit the other side's recovery from you, then you're also going to limit your recovery from them. Okay. All right. Paragraph number 10. This is the entire agreement. So all the understandings between the parties are incorporated in this agreement. So this is like the totality of the circumstances. Okay. So any other conversation that you might have had, any prior oral agreement, or you made a deal with them verbally. This is one of the reasons I hate it when my client gets together with the other agent, or my client buyer gets together with the seller, is because they frequently tend to have conversations of which I'm not a party. So I don't know what actually happened in that conversation. I just had this recently on a property that we were selling up in Idaho, actually, where we're the broker up there. And frankly, the listing agent with the seller, their seller, and our buyer, and they all worked out this deal together. When I got involved in it, I said, okay, not a problem. Everybody send me a copy of what you all agreed to. Here's something. Husband got it wrong. I mean, they had completely different versions of their understanding of what that looked like. The other agent, of course, other understanding, the seller, completely different understanding. And so now here I am trying to piece this thing together. But haven't you had that happen? Where your clients will get together with somebody and they'll make a deal. And then later on, here's the problem. If it's not memorialized in writing, then it doesn't exist. And so the risk is, of course, that we may end up in litigation over something that we weren't even there. Okay, so, buyer sues the seller because, oh, we had a deal that you were going to leave the barn. And the seller says, no, I didn't make any such deal. I was talking about that barn over there, not the barn here. This is the big barn. I'm taking the big barn with me. And of course, now everybody's on lawyers, and we're going to have that have that fight. Okay. All right. So all understandings between the parties are incorporated into this agreement. Its terms are intended by the parties as a final, complete, and exclusive expression of their agreement with respect to the subject matter. So in other words, we're talking about, we're going to go look at property, and you have given me, through the BMI, through this form, you have given me what you're looking for, and you've read the SBSA, you've read the MCA, and so you're telling me that, based on all the stuff that you've read, here's what's important to you. Okay, you can't tell me that your search is going to be based on the market continuing to improve. I always say to people, define for me what that means. The market is going to improve. Improve for who? I mean, I think the market is constantly improving for everybody, right? I mean, I'm sorry that maybe I'm going to pay a little bit more for the property today than I would have a year ago, but at least I'm paying less today than I would have paid a year from now. Okay, but then I don't know. I don't know what's going to happen in the market. If I look at the graphs and I look at the charts and all the data, we are on an upward track again. And COVID-19 was just like 9/11. I'm sorry, I shouldn't say that, but 9/11 just killed it. I mean, it was a horrible thing that happened. And you know what? It really changed our market for about 4 months, right? So September, October, November, December, and right middle of January, everything just started going again, okay? We weren't over it. It wasn't a big deal, but at the same time, it was one of those things that we had to, deal with it, move on. And that's what we're going to see now with COVID-19. We're going to see, you know what, we're just talking, I was talking to people in Canada just an hour ago, and we were talking about, you know, their market in Toronto, and we're talking about how, hey, we're marching on, right? I mean, we're moving forward. And so, you know, this COVID-19 thing for them was a moment, and then now we're going to, you know, get back to our life and do what we be doing. Okay. So it's a complete exclusive of the agreement with respect to the subject matter, and may not be contradicted by evidence of any prior agreement. So, you know, we made a deal or whatever, we had dinner, or worse, we had drinks. Okay. Remember, you never want to be drinking with your client, you know, because, you know, when they sign stuff, everything is fact, right? Okay. Or contemporaneous oral agreements. So not even an agreement that we might have now at the same time we're drafting this. So in other words, you have this conversation with the buyer and you say, well, I know the contract says this, but we're gonna, you know, you need to know, if you need to get out of it or whatever, just let me know, nudge, nudge, and I'll get you out of it. Listen, I hate those kinds of conversations. Those are going to make your contract is going to be I've lost the name for it. Contract is, it's not a specific contract. So in other words, it can be defeated by any party. All right. If you tell the client, don't worry about what you're signing, you know, it's an illusory contract. That's the word I was looking for. Thank you, Jackie. So an illusory contract. So in other words, oh, that's okay. Don't worry about what you're signing. You can get out of it for any reason. That is not going to work. Okay. You can't have that conversation. By the way, it's a disservice to your client because it creates a dispute. It's also a disservice to your broker following your broker's instruction. It may also be a code of ethics violation. Okay. And so, you know, you're leading the client with the impression that, you know, they can get out of this thing for any reason. They can call you up. Oh, you can just call me on the phone and I'll let you out of it. It's not your contract. This contract belongs to your broker. So it's not yours to let them out at any time. Okay. And I've had to enforce these. So I'm going to tell you, and so my agents, of course, would never tell the client, oh, don't worry about it, get out of it for any reason. No, we're not going to do that. Okay. All right. This agreement may not be extended, amended, modified, altered, or changed, okay, except in writing, signed by the buyer and the broker. Why? Statute of frauds says that. Statute of frauds says an interest in land, in order to be enforceable, must be in writing. And so therefore, any change you want to make to, call it whatever you want. You can call it a modification, amendment, an alteration, change. You can call it whatever you want, but the only way to change it is going to also be in writing. Okay. And remember, the DRE says that your commissions are part of that statute of frauds and therefore must also be in writing. Okay, so let's take those things seriously. So it's all going to be in writing. Okay, can't be extended, nothing like that. All right. Excuse me. In the event that any provision of this agreement, now this is the law of several. Okay. In the event any provision of this agreement is held to be ineffective or invalid. So in other words, I've got what, 11 paragraphs in the buyer representation agreement. Paragraph number 6 is held to be invalid. Okay. Well, in court, all right, remaining provisions will nevertheless be given full force and effect. So we learned those full force and effect things when we were getting our real estate license, but now you see the actual implementation of it. So this is my law of severalty. It says just because one paragraph is held to be invalid doesn't mean the entire thing collapses. And that's important to remember because a lot of times that's what the parties are trying to do. They're trying to get out of a contract. And so everybody's talking nice in the beginning, but once they're trying to get out of the contract, now they're looking for reasons why it should fail, and we don't want to give them those reasons. Okay? All right. So shall be given full force and effect. This agreement and any supplement, addendum, or modification, including a copy, whether by copier, you all know what a copy machine is, a fax. I mean, how many of us today don't know what a fax machine is? They came about in what, the late 80s. I don't know. I don't use them anymore. I have an online fax. It gets nothing but travel agency ads, despite the law that says they're not supposed to send me that stuff. So, but not many people are using faxes anymore. But even in your Zip Forms program, you have the ability to fax things. You just check, instead of email, you check the second box that says fax. You can send a page to your client that's a cover page. And then anytime they go to fax anything to you, they put that down as a cover page. And the barcode that's on there automatically scans the document into your transaction. Okay, cool stuff, really cool stuff. That's that fax. NCR, stood for National Cash Register. It was the old press down hard bottom copy is yours, okay? Or an electronic NCR or electronic, we're missing a word there, may be signed in 2 or more counterparts. So in other words, here's the document signed by the buyer. Here's the document signed by the seller. I put the 2 documents together. I hold them up to the light, and they are identical documents except for the location of the buyer's and seller's signature. Then guess what? They're enforceable against the buyer and the seller because they have been signed counterpart. So they do what we call, they pass the light test. Okay, a very interesting case I was reading recently before doing the counteroffer class. In fact, that was as Roth v. Molson. And in that case, the buyer signed the counteroffer, but didn't sign in the place for acceptance, actually signed in the counteroffer in the place to counter the counter. And so then sued to try to enforce the contract. And the court said, nah, you know what? you signed it in the other place. We're not going to say it's the wrong place, but you signed it in this other place. And so if you meant to accept the contract, you should have signed it in the right place. So make sure you have your client sign things in the right places. Okay. All right. So again, maybe signed in 2 or more counterparts. You know, if I've got a husband and wife on one side and I've got a corporation on the other side, maybe there's 3 documents floating around, all signed by a different individual. But when I hold them up to the light, if they're the same document, then I'm good to go. Okay. All right. And then finally, all of which shall constitute one and the same writing. So as long as they pass the light test, folks, they shall constitute one and the same writing. Okay. Any questions about any of that? You are a quiet group today. Let me see. Okay. All right. No questions. Okay. Well, hey, Ed, welcome. Okay. If there aren't any questions, then I've shown you everything I've got to show you, and I will invite you back. Let me pull down here. Most of you I know have already been part to the newsletter and all that, even though some of you, even my own agents, don't get the newsletter for some reason. Those Gmail addresses are a real problem. But at the end of the day, if I can do anything for you, please let me know. I'm happy to help in any way that I can. Tomorrow at 10 a.m., we're going to be having a conversation about Realtor Property Resource, the RPR. We use that program. We think it's pretty close to doing an appraisal. So we're going to be doing that program tomorrow morning from 10 until 11. And I'm sorry, we only have an hour, but we'll cover a lot of material. And as always, I try to make it as easy to understand as possible. I'm a practitioner like you. It needs to make sense, okay? It needs to be something I can pick up fairly quickly. Otherwise, I get bored and I go on to something else. All right, so that being said, in the afternoon, we'll pick up on the RPA. I'm not sure exactly what paragraphs we're on, but we're towards the end of the RPA. I'm trying to think where we are, but anyway, we're towards the end of the RPA, and so we'll pick that all up. And we'll have that conversation. And so if I can help you in any way, please let me know. I want to thank you all for being here today. And I definitely look forward to seeing you, hypothetically seeing you tomorrow. Thank you all for now, and please take care.